Uh, I would like to introduce myself. My name is Tarto Sudarsono. You can call me Tarto. Currently, my position is Head of Transnational Crime 2 Section at the Directorate General of Customs, Indonesian Customs. The committee or the host wanted me to explain about the updates on the legal frameworks on IPR or border control. While there are no updates on the legal frameworks, so I deleted them, and updates on IPR customs enforcement in Indonesia only. Please forgive me once again. I'm not used to stand up still here, so I would like to traveling around the room. Excuse me. So, for the next 30 minutes, I will tell you about the enforcement of IPR at the borders. Hold on, it doesn't work. Okay, it works. But before that, let me introduce my institution, Indonesian Customs. So you can see here, Indonesian Customs is Indonesian Customs coverage. We have 20 regional office, 3 primary office. One regional office consists of around 3 or 4 until 9 customs office, and 1 customs office coordinating several customs points and satellite offices. For those who don't know yet, Indonesia is quite large. Geographically, we have wide of range 5,120 kilometers approximately, and the range from north to south is 1,760 kilometers. We have more or less 17,000, sorry for this, it's typo, 17,500 islands. Indonesian Customs has in total 15,883 employees, and the male employees are 83% and the rest is female employees. Okay, that will be a brief introduction from us to Indonesian Customs. Okay, let's continue to IP things. Indonesian Customs has ex officio authority, but only for 2 IPs, trademark and copyright, while the others is non ex officio or judicial scheme. Let me explain it for you. In terms of ex officio scheme, it needed to be recorded priorly. So customs will be actively engaged in IPR enforcement at the borders. However, the right holders have to record their trademarks or copyright before that. So we will be actively control the IPR infringements at the borders. However, the judicial scheme also implemented in our territory, but we are in condition of passive. We have to receive the temporary suspension order from the commercial court. Okay. This is the legal frameworks of IPR enforcement in Indonesia. At the borders, for example, here we have the law of customs. Since 1995, there are 11 articles explaining about IPR enforcement. And until then, we have government regulation number 20 in 2017 and Ministry of Finance decree in 2018, completed by commercial court regulation in terms of temporary suspension orders. Okay, the recordation requirements are these. These are the documentary or the requirements that needed to be for the trademark owner or brand owners to record their trademarks to Indonesian customs. However, the first and the most challenging part of recordation is this one. The right holder must have business entity in Indonesia. I'm sorry for brand owners from abroad, from international trademark. Yes, at the moment, we still require you to have business entity in Indonesia or subsidiary company or something like that. And you have to appoint examiners. One examiner is enough, but we suggest you to appoint more than one examiner because the examiner is the one who will be contact point from Indonesian customs whenever there is an alleged in IPR infringements at the borders. We will ask them, we will contact them to answer our questions whether this is your product or not. Examiner. The recordation in Indonesian customs valid for 1 year and it is extendable. Okay, and we always look at the data at the DGIP for the certificate of trademark. We have to validate. So I will repeat once again. The recordation requirements is 1, you have to have business entity in Indonesia. You have to apply. And the third, you have to appoint examiner. But one thing that I would like to point out that the recordation process is free of charge. We don't take anything from the trademark owner or the brand owner or the rights holder. See, Indonesian Customs is one of 5 or 6 and institution. Pak Rifadi, how many institution is in the IPR task force? 5. Okay, 5, led by DGIP, alongside with the Indonesian National Police, National Agency of Drug and Food Control, and Komdigi, or Ministry of Communication and Digital Affairs. Some of the participants are from this IP task force in Indonesia. We hand in hand collaborate, coordinate to tackle counterfeited products in Indonesia and piracy. Okay, when we're talking about recordation, the data of recorded trademarks is increasing. The trend is increasing. As you can see here, in 2023, there were only 32 brands recorded at Indonesian customs system. However, in 2024 and 2025, the number is increasing rapidly. At the moment, there are 85 trademarks recorded in Indonesian customs system. These are the brands. Combination between domestic business origin and from foreign business origin. You can see here Standard Pen Indonesia from domestic, from national, domestic, and we have PNG from foreign countries, Paragon domestic, 3M from foreign, Glaxo, and so on and so forth until the last one recorded is here, Sejahtera Multi Manufacturing Indonesia from domestic is a soap. You can see here the chart here. Yes, indeed, the domestic business origin is higher, a little bit higher than the foreign business origin. Okay, because of the requirement, I believe, the requirements of business entity in Indonesia. Okay, if you want to know, if you want to look at the updated list of recordation and the trademarks that are recorded in Indonesia, you can go here to Instagram. Our Instagram is @recordasi_bea_cukai. There is a link tree here. You can see updated recordation list in this link tree. Okay. We have to open the data because the trademarks which are recorded at the recordation system is needed to be prevented. Just to prevent the importers to import the counterfeited products. How about the IP infringement seizures from Indonesian customs? Yes, from 2019 until 2025, we had 20 IP infringement seizures. The data is mentioned here: 1.1 million pieces of ballpoints, 160 rolls and 890 cartons of sandpaper, 5.3 million pieces of razors, 72,000 pieces of cosmetics, 1,600 cartons of masks, 1,320 cartons of cigarettes, and the last one is 444 cartons of aquarium water pump and accessories. From these 20 IP infringement seizures, 13 of them were escalated to commercial court by the right holders. Why not all? Yes, because it depends to the brand owner whether they want to escalate the seizures to commercial court or not. It depends on them, so we cannot push them. These are the example of the seizure. In 2025, on April 14th, at Tanjung Priok Port, Tanjung Priok is the the busiest port in Indonesia, in Jakarta. The goods were razors or shaving blades. The brand is Gillette. The right holder is Procter & Gamble, and total seized is 70 cartons or 740,000 pieces of Gillette, like this one. So this is counterfeited products. The judge of commercial court had decided that this is a violation of IPR law in Indonesia. Next, last month, on July 4th, 2025, this is an island called Sangihe. This is Philippines. This is an island, almost the northest part of Indonesia. This is Celebes or Sulawesi. Tahuna bonded warehouse. The goods were cigarettes. The brand was Bros Premium. The right holder was this, Tembakau Jaya Saktisari, and the total seized was 1,320 cartons or 13.2 million sticks of cigarettes. So, in conclusion, not only at the main ports of Indonesia, but also at the borders and in remote areas like this, Indonesian customs are there. Indonesian customs controlling the border, and we managed to seize the IPR infringements at this remote island in Tahuna. This is the example of how effective recordation system in Indonesia. The last seizures was on July 23rd, 2025. Again, back to Indonesian busiest port, Tanjung Priok. The goods were aquarium pumps and spare parts. The brand is Sansan, like this one. It came from China. The right holder was PT Raja Pet Pasti Sukses, 444 cartons. And the commercial court judge has decided that this is IPR information. Oh, I forgot to mention that these cigarettes were produced in Vietnam. So this cigarette should be produced in Indonesia, in Java, in East Java. The brand owner is from Malang, Jawa Timur, East Java. However, somebody took advantage of this brand because this brand is well known and the sales is quite good in the Philippines. So somebody took the advantage of that. They managed to produce this brand the cigarette brand in Vietnam, send it to Indonesia, and it will be sent to the Philippines from this remote island in the northern part of Indonesia. So you can imagine how devastating the brand owner will face if these cigarettes manage to be exported to the Philippines. All right, then. Okay, I think the last slide is the exceptions. I want you to understand, and I want you to get to, that Indonesian custom is not that powerful in terms of IPR control, not like other customs in Europe, for example, or in Japan or in US. We have limitation of authority. This is the limitation. So the suspensions of the release of goods suspected of infringing intellectual property rights does not apply to 1. Passengers' personal belongings. 2. Crew's belongings. I mean the airplane or the flight attendants, the pilots or something like that. And the land border crossers goods. We have land borders and we have people who live at the borders back and forth to Malaysia, to Papua New Guinea, and to Timor-Leste. So it is exceptional for them. And postal or courier shipment. Sorry to disappoint you guys. I see the European delegation. Oh, because yes, we do not have the authority to control postal or courier shipment in terms of IPR. We have to let them go, even though we knew exactly these goods are counterfeited. All we have to do is take notes, and we will send the information to the right holders. So it's up to them if they want to ask DJIP or Indonesian National Police to follow up that kind of information. So these goods which are not intended for commercial purposes are not part of the Indonesian Customs Authority. However, this exception shall not apply if, based of the professional judgment of customs officers, A, the quantity of or nature of the goods is unreasonable for personal use, and or the goods are intended for industrial, corporate, retail, institutional, or other non-personal purposes. So, even though it is postal or courier shipment, but the amount or the quantity is not normal for personal use or for, what do we call it, for souvenirs or gifts or something like that. Yes, we have the authority to make it as a commercial good. So the IPR infringement is managed to be conducted to that kind of goods. All right, then. I think that will be all. Thank you very much for your kind of attention, and I look forward for the discussion later on this afternoon. Thank you very much, and have a good day.